I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Please have a seat. Yes, Mr. Coss.
May it please you, sir. If you could give us your full name, please.
My full name is Stephanie Alice Roberts-Bibby.
And I think before we start your evidence, Ms Roberts-Bibby, there was something you wanted to say.
There is, yes. I want to offer my heartfelt condolences to the families of Alice, BB and Elsie and the others that are harmed by the actions of AR and impacted by the events on the 29th of July 2024.
Thank you very much.
Thank you.
Could we have YJB 4076, please? Is that your witness statement for the inquiry?
Yes.
Signed on the 3rd of September 2025 on page 48, and is it true to the best of your knowledge and belief?
It is, yes.
Ms Roberts-Bibby, I think you are the Chief Executive Officer of the Youth Justice Board and have been since June 2023.
Yes, that's correct.
I think you served in other senior roles in the Youth Justice Board from 2018, but previously had a career in the prison service, including 11 years at governor grades in both prisons and young offender institutions. Is that right?
It is, yes.
I'm sorry, Sarah, could we have that back up on page 7, please, because you set out a little about the Youth Justice Board. It's a non-departmental public body, one of the Ministry of Justice's arm's length bodies.
Yes.
And its role is to monitor the operation of the youth justice system, which includes advising ministers. Other functions include commissioning research. Is that a strand of the Youth Justice Board's research which has, in your view, has been effectively enabled and supported in recent years?
So we have changed the way that we've delivered research in recent years due to investment across other parts of government. So for instance, we have a very small limited budget for research. We can undertake 2 internal research projects a year and can commission out the same amount. As a result, we rely heavily on other research bodies such as the Youth Endowment Fund, who have had a bucket of investment to be able to develop the evidence base on how to prevent children causing violence.
Just slightly slower.
Sorry, I try harder.
Thank you. One of your other functions, and you set out those in paragraph 36, is providing assistance to local authorities and others in connection with youth justice system information technology systems. Is that really in the realm of providing advice and guidance? You want a commissioning authority or a provider of such systems?
It's both. So we provide the IT infrastructure which exchanges information on the children who are in the system. And then what sits on that infrastructure is the assessment tool, so Asset Plus. And alongside that, we will provide guidance on that IT infrastructure.
We'll come to Asset Plus shortly.
Okay.
As we've heard, at a local level, youth justice is delivered by youth offending teams, more often now perhaps known as child and youth justice services. What we've heard is that in Lancashire County Council, this is staffed by social workers and probation staff. Is that a typical setup?
A typical setup is probably a broader multidisciplinary team. So a range of youth justice workers, social workers, a seconded probation officer who have a critical role in helping identify risk to the child, to self and others. And then a range of others from the statutory partners, so for instance health, staff who will be able to help with speech language communication, neurodiversity, an education officer. Those are the things that we would expect a true multidisciplinary team representing the statutory partners. Do you want me to tell you who the statutory partners are? Would that be helpful?
I think you've set that out in your statement, and we can take that as read. Can we zoom out a little to the youth justice system generally? The principal aim of the youth justice system is to prevent offending by children.
Yes.
And that differs then from the aims of the criminal justice system as it relates to adults, in that in particular there is no punitive element of that system.
the aims and objectives are solely to prevent a child causing harm and causing victims.
In paragraph 35, so the previous page, please, Sarah, you talk about the vision of the Youth Justice Board as for a youth justice system that sees children as children. I think the youth justice system operates on what sometimes is referred to as a child first, offender second principle. Can you expand on that a little?
Sure. So this is the underpinning theory of change that evidence tells us is the most likely to impact on preventing children offending and reducing offending. And there are a number of tenets in that evidence base. So the first is that we acknowledge that children have a unique set of rights and responsibilities, and that as adults, it's our responsibility to meet those. The second is building a pro-social identity with that child. So finding what they are good at, building on it, and giving them a positive identity rather than a criminal identity. The third is making sure that the child is at the centre of all the work that is done with them, and that they have a voice, and that they are engaged, and that they understand what is happening. And the final is destigmatising them, so making sure that we are not bringing them into the system and giving them every hope and chance of desistance from future offending.
An outsider might detect, at least in some cases, a tension between that very child-centred approach and the need to protect the public from harm. Would you accept that there is a tension?
I think there's a perceived tension. I don't think in reality there is. Our evidence shows us if we meet child's needs, address those needs robustly, that we have a much greater chance of protecting the public and reducing harm to others.
So no actual tension because of what the evidence base shows, but a perceived tension on the part sometimes of others looking in. Does that then perhaps lead the Youth Justice Board, the Youth Justice system, to have to push back against that perceived tension, which might in turn lead to more emphasis being placed on the child first element and less on the preventing them from being victims, preventing them from being harmed?
I do think we absolutely have to push back and always go back to the evidence. So what does the evidence tell us? This offending and harm is a highly emotive area, understandably. I think that one of the real challenges is getting the public, practitioners to see that that need and risk are two sides of the same coin, and we need to consider them together.
Thank you. Can we talk about some of the tools that are available now in the youth justice system? If we could go to page 14 of this statement, paragraphs 58 to 60, you describe some of the out-of-court outcomes. Informal ones, including community resolution and decisions to take no further action. Formal ones, the lowest levels are youth caution and youth conditional caution. Mm-hmm. Could you help us, first of all, on the difference between the two?
Yes, so a caution is a warning. A conditional caution is subject to requirements so that the child does things. Those are at the lower level of the formal outcomes.
In terms of conditions, what sort of conditions might we be thinking about here?
Attending education would be an example.
And are there consequences for failure to comply with those conditions?
For a youth conditional caution?
Yes.
Yes, that would then mean that you would then escalate through the system.
And who monitors and enforces compliance with those conditions?
The Youth Justice Services.
So once a conditional caution is imposed, that child is then...
on a caseload.
Yeah.
Yeah.
Thank you. At 59, one might detect a certain wariness about the use of formal out-of-court disposals. Is that a fair inference to draw from where you talk about them not being routinely used for children committing first-time and less serious offences, or their use being reserved for children who'd otherwise receive a court sentence?
Sorry, can you just repeat the first part of your question?
Yes, one might detect a degree of wariness about the use of these formal out-of-court options?
No, there's not a wariness. I think that what we are trying to say is that we should be responding to each child on a case-by-case basis. So we shouldn't be throwing a blanket over this type, because we know, again, the evidence shows us that we should be treating children on an individual case-by-case basis. So there isn't a wariness on our behalf. It is about making sure that professionals are using their judgment for the best intervention for that child to prevent harm being caused.
Thank you. From paragraph 62, you set out the various court outcomes. There's a wide range of them, and I want to focus on the ones that are, first of all, within the powers of the youth court, so we can set aside the Crown Court outcomes. And I also want to, we don't need, I think, to focus on absolute and conditional discharges and on fines. Okay. So setting all of those aside, we have referral orders, we have youth rehabilitation orders, we have youth rehabilitation orders plus intensive supervision and surveillance, ISS, and then detention and training orders of up to 24 months.
Yes.
The last of those is a custodial sentence. From paragraph 65, you set out the statutory framework around referral orders. There's 4 aspects of that I'd like to explore, please. First of all, as with any other court outcome, the duration of a referral order is set by the court.
Mm-hmm. Yes, that's right.
But the requirements of a referral order are not set by the court. They are set by an agreement between the child and a referral order panel at some point after the order has been imposed.
That's correct, yes.
Does that create a risk that the work which is identified as needing to be done is not aligned with the duration of the order?
No, you would expect that the work to be done would align with the order. However, if the work needed to continue with the child after, that could continue on a voluntary basis.
Secondly, there are cases where the imposition of a referral order is, in effect, mandatory for the court. And you've set those out at paragraph 67. Imprisonable offence, guilty plea, and never been convicted by or before a court of any other offence. Given the understandable, and obviously, as you say at the top of that paragraph, that doesn't apply where the court is considering a custodial sentence. Given the understandable reluctance to impose custody on children, is it the case then that for the vast majority of first-time offenders in youth court, so long as there's a guilty plea, the outcome is going to be a referral order?
Yes, highly likely, yes.
And so, save for the court setting the length of the order, there's little scope in those circumstances for the court to tailor the outcome to the individual case.
Yes, that's not for the court, that's for the referral order panel to set the requirements.
And so it wouldn't be open to the court to take the view that this was a particularly serious episode of offending, even though it was a first-time offence, even though there was a guilty plea, and therefore the additional rehabilitation requirements under a youth rehabilitation order, for example, would be available. That simply isn't an option.
No, that would only be available if a youth rehabilitation order was then given by the court.
Yes, which it wouldn't be able to do in those circumstances. Why is that the case? Why should the court's powers be so fettered when it comes to dealing with even examples of particularly serious offending, albeit ones that don't pass the custody threshold?
That's the current sentencing framework. Of course, this is an opportunity to reconsider that. And our position would be that there would be an opportunity to revisit referral orders where a child is found with a knife where there's intent to cause harm.
Yes.
Do you think that should be revisited?
Yes, we would recommend that that is revisited where there is intent to cause harm.
Thank you.
Thank you.
Mr. Goss.
No, thank you, sir. And at paragraph 74, on page 17, there was some suggestion that that was likely to be your position, but you have made it very clear now. The third point about referral orders, implementation, paragraph 73, you set out where they are the most effective. In short, it requires strong engagement from both the child, but also from the Youth Justice Service, the Youth Justice Service that is administering the referral order.
Yes, and of course the statutory partners who
Yes.
should be working collectively to address the needs of that child and to make sure that the requirements of the order are fulfilled.
So a referral order, once imposed, shouldn't be treated simply as any sort of tick box exercise, either by the subject of the order, but equally by those administering it and those involved, both the Youth Justice Service and the multi-agency partners.
No, it should be both inspirational and aspirational for that child.
How does a process of what you described there of challenging constructively and working collaboratively with children and families, how does that mesh with the ability of the Youth Justice Service to deal with enforcement where referral orders are breached?
That is part of the role of the Youth Justice Service. If there is non-compliance, it is absolutely incumbent on the worker, the lead worker, to seek to engage with the child, find out why they're not engaging, and then do everything they can do to inspire them to engage. If they fail to do that, it is very clearly then non-compliance and a breach.
And where there is a breach and where there has been an attempt to engage and that hasn't been successful, then it's incumbent on that Youth Justice Service to deal with that through taking enforcement action.
Yeah, and that would be a return to court.
Yes. In terms of, and the fourth point on referral orders, you deal at paragraph 70 to 71, just above the extract that's on the screen now, with reoffending. And you've given us the data for the year ending March 2023, low reoffending rate and low reoffending frequency rate, i.e. Both the absolute issue of reoffending and secondly, where there is reoffending, how much reoffending there is.
Yes.
Those are the figures for a single year. Is that a typical kind of pattern?
Yes, it is. And if it would be helpful, we can add an addendum to our corporate witness statement for the statistics for 24, because we've been doing some additional work on that, if that would be helpful. But that is, yes, it's been typical for the last few years.
Thank you. And yes, we'd be grateful for the last year's update. That would be extremely helpful. I think there you acknowledge the limitation at paragraph 72 of some of the statistics. One issue is the referral orders are obviously likely to be imposed where there is a shorter or no offending history. And of course, they must reflect a guilty plea.
Yes.
You'd need to control for those kind of factors to be able to compare effectively with the reoffending rates on other outcomes.
Yes, correct.
And at the moment, the data simply isn't available to do that.
Yes.
Likewise, of course, it might be influenced by the severity of the underlying offence.
Absolutely, yes.
You talk there about there being a piece of analysis and research that you should be allowed to undertake. Is there something stopping that from being done?
This is purely capacity, organisational capacity and funding, and in particular because previous ministerial direction, go back to sort of 2021, was that they wanted us to do less research because they had, across government, been investing in other areas of research. For instance, as I spoke about earlier, the Youth Endowment Fund and UKRI and other big organisations across government undertaking research.
So there is an element to which you are not wholly in control of your own research programmes and directions.
Yes, and I do also think there is a need to pull together strategically clarity on what are the big questions we want answering, and then making sure that the research answers those for us to really give us the evidence base that we need going forward.
Thank you, and we'll come back to that.
Okay.
Other court outcomes beyond referral orders, youth rehabilitation orders you've dealt with at page 18, paragraph 75 to 78. It's apparent from paragraph 75 and 76 that they're a much more structured and potentially more intrusive measure than a referral order. You describe them elsewhere as being roughly equivalent to a suspended sentence in the adult justice system, although obviously they don't come with the threat of custody as an automatic consequence. For YROs, as we've touched on, it's for the court, not the Youth Justice Service, to decide on the requirements. You'd expect that to be informed by a Youth Justice Service pre-sentence report?
Yes, absolutely. Again, identifying needs and areas that the child needs to work on.
And you tell us that more than a third of YROs are successfully completed from the point of sentence, and the remainder, most of the remainder are successfully completed, albeit that there may have to be breach action, perhaps once or twice in the early stages. Is that a fair characterisation?
I think so, yes. I think that is, yes.
The maximum duration for a YRO, up to 3 years?
Yes.
Presumably that would be for cases, a full 3-year length would be for cases that fall perhaps just below the custody threshold.
Absolutely, yes.
And then in terms of custodial outcomes, in the youth court, the only custodial outcome is a detention and training order. It comes in 2-month steps, 4 months, 6 months, 8 months, and so on.
Yes.
And of the total period, that up to half would be served on supervision in the community.
That's correct, yes.
And just while dealing with custodial outcomes, for certain cases of where there are multiple offences for carrying a knife, there are mandatory minimums, as in minimum custodial sentences that have to be imposed. The exact number, the exact sentence, depending on age, but these don't apply to offenders under 16, is that right?
That's right, yes.
Thank you. If we could turn then to multi-agency working in the youth justice system. At various points in your statement, you expressed concerns about how the multi-agency system for preventing youth offending and protecting the public works, both at a local level and also at a national level.
Yes.
Could I try to summarise those concerns, and please do expand on any of them that you think I am not doing justice to. First of all, there is a difficulty over who owns the risk of harm or reoffending, particularly or there can be, particularly at a local level, because it shouldn't simply be the Youth Justice Service that owns that risk. Is that fair?
Yes, a collective risk, although there should be a lead worker. So in this instance, you would expect the youth justice worker to have been the lead worker, but getting information from, getting views from and advice from the other statutory partners.
That brings me on to the next point I was going to make, which was challenges over the sharing of information and how that is passed between different agencies. That's a perennial challenge.
Yes, although I think from my operational background, people tend to make a bigger issue of this than is necessary. The information should be shared in the interests of preventing offending and harm to others. I see no reason that professionals have that capability, and they should have the confidence to do that. Can I just add, they should also have the humility as well when other professionals who come from a discipline perhaps raise a concern to reconsider whether the risk needs to be reviewed or amended or adjusted, and then indeed the associated plan. Thank you.
Another challenge is different agencies defining risk and vulnerability in different ways.
Yes.
How is that something which the Youth Justice Board would have a role in seeking to address?
So I think that there's definitely something to take forward about how those statutory partners have an agreed understanding of what the word risk is. We have a definition in our guidance, which I think certainly after the inquiry we will be reviewing all of our guidance and documentation to see whether that needs to be revisited in the light of any learning. But there is definitely something about having clarity of risk, who's owning it, who is responding, and putting a plan in place. And then if that plan doesn't mitigate or manage the risks, what the escalation route is afterwards.
Yes, because you identify that there is, at present, no escalation intervention available where risk is increasing.
Yes.
What you have suggested, page 4, paragraph 19, is the ability where there is increasing risk for agencies to trigger an 8 to 12 week period of accommodation with trauma-informed holistic support. I think there's a model in London that for children on remand that provides something similar. Is that right?
Yeah, so I think that there are two issues. I just one pick, if that's okay. I think there is something for children in justice and being very clear about the escalatory route. I think there is then a gap for children who are not having a justice intervention or an outcome around how we prevent them causing harm to others. And that feels to me to be a gap. Some of the work that we have been doing in London is a justice intervention. Mm-hmm. It is an offer of trauma-informed holistic wraparound support with accommodation, so to prevent children being remanded, because we know that taking children into custody has really damaging effects. We know that of the children who are currently in custody, about 40 to 45% of those, 2/3 of them do not get a custodial sentence, but we know that we have damaged those children by taking them into the depths of custody. So we have been developing work with London for an accommodation offer, which does include some control measures. So if children could pose a risk to others, they have a curfew, they may be tagged, they have a number of conditions to which they have to reside at that property. But the purpose is to make sure they are safely accommodated, that others are safe, and that we are working with them to meet their needs. There is, it feels as though, no comparison for that in the world of social care. I mean, however, I think fundamentally that's coming from the inquiry is whether there is a role for social care to think about risk of harm to others. That feels to me like that is a gap. And I think what I don't know from the evidence I have seen is what would have happened next in terms of social care intervention. At what point would AR have been removed from the home? I don't have the answers to those questions, but I think it would be helpful to understand the escalation route, and then what is the legislation that might be required if there is a gap.
Thank you. In terms of models for improving multi-agency working, the actual delivery on the ground is a local matter.
Yes.
And there are no doubt many different models across the country. Could I suggest what might be some possible models? No doubt there would be others. We've heard a good deal about the child protection model under working together to safeguard children. Essentially, you have an agency such as Children's Social Care, which is the lead authority.
Yes.
That convenes multi-agency forums when a particular issue around a particular child is raised, and it follows set processes as and when risks are identified. Another might be MAPA type arrangements, where there is a defined threshold before an individual is open to MAPA. And I think that children can be open to MAPA, but there is quite a high threshold in terms of custodial sentences having previously been received. There's the PREVENT model, referrals being made in where there's a suspicion and then a statutory power and duty to refer on where certain thresholds are assessed as being met. We've heard yesterday for the first time about multi-agency support panels operating in Lancashire as part of the serious violence duty. That may be another model, and we're expecting to hear more about that. As I say, no doubt there's other models. There's one, I think, in Greater Manchester that you wanted to say a little about.
So there is work being done across Manchester where there is an organisation called Shift who are working with the local authorities in Manchester to have a guide model. So a child has a single point of contact, a family has a single point of contact, and that guide literally guides them through processes to make sure that there is a reduction in risk of offending and a reduction in risk of harm. So it's a merger of children's social care with youth justice, which we haven't got any evidence, so I can bring you in terms of outcomes and effectiveness. So again, we can commit to giving you something outside of of today, if that's helpful.
I think from the entirety of your statement, what is clear is that it can't simply be a matter of business as usual in this multi-agency space for dealing with risk of harm. It isn't simply business as usual but with some tweaks or enhancements. There is a need for a relatively wholesale, fresh look at what processes are in place.
I think that there is the need for an unrelentless focus on children who have the greatest need, vulnerabilities, and therefore potential to cause harm.
Does that need to be led at a national level?
I think that needs to be led at every level of the system. So at local level, there are fantastic services. I should make the point, there are some some fantastic work being done in youth justice, and that's reflected in the outcomes that have been delivered. That doesn't mean that there isn't much more to do. There is. And we can give examples of where that local prevention practice is strongest, as we see it across England and Wales. That needs to be mirrored, in my view, by strategic governance that reflects the statutory partners at a very, very senior level. And when I say senior level, I would suggest ministerial level by the Secretary of State for Justice, which is currently the Deputy Prime Minister, being able to convene ministers to be able to say, this is what the evidence tells us, this is what needs to be done, now let's get on and do it. And there is a real opportunity to be able to do that at this time.
Thank you. So I think that's probably as far as I can go, consistent with our phase 1 terms of reference, but I'm sure these are issues that the inquiry will be returning to in phase 2.
Food for thought.
Can I turn then to AR's contact with the Youth Justice Service? The first point is this. I think because it follows from the evidence you've given about referral orders that at the point AR was brought before the Youth Court in February 2020, because he pleaded guilty, because it was the first time he had received a conviction, there was no option for the court other than an RO or a custodial sentence.
Yes.
And this was it was never going to be a custodial sentence, so an RO was really the only option.
Considering his history and his age, yes.
Would you agree with this? This was a case where there were multiple offences. He'd been charged with assault occasioning actual bodily harm, possession of an offensive weapon, and possession of a knife. There was relatively sophisticated offending in that there had been some planning gone into it. He'd booked the taxi the night before, he'd modified the weapon. Notwithstanding his guilty plea, there were signs of an absence of remorse, and there were other significant indicators of risk, some of which had been captured in the prevent referral. That might have been the kind of case where more intrusive, more tailored powers under a youth rehabilitation order might well have been beneficial.
Yes, although there is an opportunity for the panel to be being really clear about expectations of what they would have wanted him to have done.
We'll come to the panel shortly, but for the court, it would perhaps have been beneficial for them to have had the ability to tailor requirements, more intrusive requirements than simply imposing a 10-month referral order.
To have a greater range of activity.
Just on a practical point, it appears that this case was prepared as a guilty anticipated plea case in the youth court, which had the effect that certainly when the Youth Justice Service first received information once the referral order was imposed, all they received was the initial details of the prosecution case, which didn't include all of the witness statements taken by the police. Is it possible that in that situation that the information available to the court might not have reflected the totality of the police investigation? Yes,
it could be the case, and it's quite common in in the magistrates' court. However, there was clearly more information known about AR across other elements of the local authority, and they did know that he was during court, yet Youth Justice Service didn't. So I think there is something about lack of join-up across the local authority landscape.
Turning then to the implementation of the referral order in this case, I think you're familiar with the evidence that Ms Callan gave to the inquiry.
Yes, I am.
Would you agree that there were significant limitations to how this referral order was implemented?
Absolutely, yes.
We remind ourselves of the COVID context, but some features of it, that the objectives set by the referral order panel, to the extent that we can say what they are, appear to have been very limited.
Yes, from what I've seen, very, very limited.
A significant proportion of the contact with AR over the referral order period was by telephone only. That's perhaps not as collaborative or constructive as it might be.
I mean, I feel quite frustrated from looking at that evidence and the documentation. The role of the service is to engage the child, to work with the child, to hold the child to account, to set appropriate boundaries. And of course, with boundaries, if you break them, there have to be consequences. Whilst it was during the pandemic period, and I understand how very difficult that was for everyone, there could have been, other ways of working, going and standing on the doorstep, speaking to AR and his family, workers coming together in an open space if you had significant risks, if there were significant concerns about risk. Be ambitious and have an appetite to get what you need to get done.
The only structured work that we've been able to identify was 3 sessions, 30 minutes each, on no knives, better lives, victim awareness and anger management. Is that consistent with what you see as the objectives of a effective referral order?
No, I would expect to see more. That seems very light. It appears as though there was very limited discussion with him about what was going on in his life from a youth justice perspective. Now, that may have happened, but that's certainly not recorded in any of the evidence. So I would have expected the caseworker to be forming a relationship with him, understanding why he had done what he had done, working that through with him, trying to give him insight, working on victim empathy, thinking about consequences, thinking about how he's, at that point, undiagnosed ASD, was playing out in his world. What was that meaning for him? Why did he have a perception of victim and now was, that making him perpetrator? All of these things I would have expected to have been taking place with the worker and the child.
Is an element of that engagement also for a child of AR's age, engaging with the parents as well?
Oh, absolutely.
So that they understand the purpose of the CYJS intervention, the benefits of engaging with it constructively.
And also being consistent. So we know that children who have neurodiverse conditions need consistency of boundaries and treatments. And similarly, consistency of I'm going to speak to you in 2 weeks' time, speaking to the child in 2 weeks' time, not 2 weeks and 3 days or 3 weeks. Actually, as a worker, do what you say you're going to do, because again, that is modelling in the right way how people behave for children who might not have the same cognitive processes as we as adults or responsible adults have.
We know that there were a number of cases where a refusal by AR to engage with the CYJS team were essentially overlooked and put down to his potential ASD. To some extent, one can perhaps understand that,
yes.
But is that an approach that you would endorse as one occurring time and time again?
No, I think that there is something about professional judgment and an element of leniency on first, maybe second. After that, I think you then are into the realms of this is now non-compliance. And that's when it's really important that, again, talking of the role of parents play such a significant protective factor in preventing children offending.
We know that the CYGS conducted a number of Asset Plus assessments, and you mentioned that earlier in your evidence. Can you just give us an outline of what the Asset Plus assessment tool is? So you'll recall we've looked at the Youth Justice Board's guidance on it, which was at LCC 201732. But just as a thumbnail sketch, if you would. So
Asset Plus is the tool that frontline practitioners use to gather information, store information, and then analyse that information to identify potential risks the child may pose to themselves and others, and then to help inform the plan to make sure that they are addressing all of those needs as best as they can to prevent future offending.
A short point. Would you see there being any issues in sharing the contents of an Asset Plus assessment with other professionals engaged with a child?
No, you may need to remove things like an address, as an example, but it is a professional document that can be shared. It is cumbersome and clunky. I think I should absolutely say that. We would really like to be able to review that, and we will review the guidance. But the infrastructure, the IT infrastructure, is clunky, which means that the format in which you then have to cut and paste and copy it is not the easiest to read, but nonetheless that doesn't mean it can't be done or shouldn't be done.
Thank you. Ms Callan accepted in her oral evidence that AR should have been graded as high risk of harm to others under Asset Plus. I don't think you would disagree with that to the extent that you're familiar with the facts of the case.
No, I think that it is ambiguous as to what the then case manager did or didn't know. However, off of what I think they may have known, which was previous taking of weapons into school, a known victim with intent to cause them harm, the fact that they had then planned to go to do that, that then, yes, I think that a high-risk assessment would be right.
How would you expect somebody assessed as posing a high risk of serious harm to others to be managed on a referral order?
I would expect a much greater level of engagement. I would expect there to be a contracting with the child and the family about how often they're going to contact them. I think the word normal is used in some of the evidence. That isn't included, I don't think, in the guidance. So it should absolutely be about what is needed. I would suggest in this instance there is a reduction in the contact. I think, if anything, actually, where there's non-compliance, you should be seeking to increase the contact so that the child knows that you are relentless in engaging with them. You are there for them. You are going to make a difference. You are not going to go away. And when we speak to children who have been really successful through the youth justice system, the one thing that comes out is the importance of relational practice, knowing that there is someone that you can go to who is actually going to help. They're not going to give in to you. They are going to hold you to account, and they're then going to make sure that they can help manoeuvre you through the things you need to do to be a successful child and into to adolescence and out to young adulthood.
Yeah. You've described the Asset Plus tool as a clunky one. Is it that the assessment methods and analysis and the information that it records is appropriate, but it's simply the infrastructure that is difficult to work with? Or is the tool itself something that you think needs to be refreshed, brought up to date?
Both. So the latest the guidance is from 2014. It was written, bless you, on a previous evidence base. So the evidence base has significantly evolved over the last 10 years. We know much better now about what works. We have made some refinements to the tool. So we've developed a lighter touch tool for prevention and diversion cases, which the sector have given us much more positive feedback about than Asset Plus. But we could do better and more if we were able to do so.
And there are obviously other risk assessment tools available within the broader world of probation, ARMS for sex offending, ERG 22 for extremism risk. We've heard evidence about the tools available to FCAMs, such as the SAVRI assessment. One thing you've suggested is that an effective risk assessment tool needs to be developed. By whom?
So I think this is the question, isn't it, about if it's about risk to others and risk of harm. Does that sit in justice? Does that sit in children's social care? It is there are 5 statutory partners. Should it be collaboratively developed across those partners, reflect all of the work that they do? And you could do something quite nifty in terms of the way that we can now work with IT and data systems, that the system would be able to say, oh, you've mentioned here that this child has a tendency to go online and look for extreme information, then signpost you to the relevant bespoke risk assessment that then brings it all back together. I mean, you could do something very, very exciting, and there are enough clever people that could bring that together. So my answer is I think it needs to be across the statutory partners, because we know that that is what's the most effective in preventing harm.
Because you want to capture all aspects of risk, because there is potentially going to be cross-cutting themes between mental health, extremism, crime of various kinds. And
sadly, that is very, very apparent, tragically, here. And I think also in previous work that you, Chair, have done in Forbury Gardens, some of the information is there. It is just not always accessible to the right people at the right time.
Because, of course, as well as there being an issue over the adequacy of the tool, there is also always going to be a question as to how that tool is used and put into practice. And so we need to bear in mind both of those elements when thinking about how to carry out effective risk assessment.
Absolutely, yes.
Just finally on that, you would expect any such tool to take into account the potential impact of ASD, which in some cases, not of course in all, but in some cases can act as a powerful increase in risk.
Yes, absolutely. As well as speech-language communication needs, social, emotional, mental health, all of the things that we know are prevalent in cohort of children who cause serious harm.
And that perhaps comes back to the point about it needing to be across the statutory partners and needing to incorporate mental health services, because the risk is a cross-cutting one. Absolutely.
And critically, the skills of those staff are really needed in the appropriate interventions to then work with that child.
Two final points on AR's contact under the referral order. Firstly, we have heard evidence that there was a incident in AR's home in January 2021, right towards the end of his time at the referral order, but while it was still in force, where he assaulted his father in the context of an argument about initially a minor domestic dispute that escalated into AR threatening to break his father's laptop and then kicking his father in the testicles when he tried to stop him, which AR's father then responded inappropriately to by striking him. That came to the attention of Child and Youth Justice Services. Would you have expected that to have led to a reassessment of risk?
Definitely, yes. Any change in circumstances should result in a reassessment of risk. And ultimately, from both perspective of AR in terms of his safety, but also, of course, again, risk to others, in this instance, his father.
What options might have been available to the Youth Justice Service at that point, right towards the end of the referral order?
There could have been an offer to work with the family on a non-statutory basis in terms of prevention activity. That absolutely could have been an offer from the Youth Justice Service, as well as the work with children's social care and perhaps a more robust offer for the family in terms of some multi-systemic family therapy. There are other things, and that may have happened. I haven't seen that in the evidence that I've seen, but more work with the family to understand what's actually happening.
Thank you. In fact, I'll move on now to March 2022. We know that AR was found on a bus with a knife, having been reported missing from home. He told police he intended to stab someone to get social media accounts deleted. He wasn't arrested, but was taken home back to the care of his parents. I think applying the Crown Prosecution Service's guidance and what you talk about in your witness statement as the child gravity matrix, you'd have expected him to have been charged with an offence in relation to that.
Yes, yes. That's what the guidance states. We would have expected an arrest and charge.
Had that been the case, there would have been no mandatory minimum sentence because he was still under 16.
Yes.
But the court would no longer be bound to impose a referral order because this was not a first offence.
Yes.
So even if he pleaded guilty, the court would have had a wider range of sentencing powers available.
Yeah, and a YRO or a YRO with ISS could have been considered.
Could have been, or do you think it's likely it would have been?
Highly likely it would have been, yes.
I'm not going to ask you to try to forecast what the requirements of that order might have been, but in terms of duration, are you able to give a sense of what you think a likely duration for that YRO might have been?
I don't think it would be the maximum, but it certainly won't be in the minimum. I think it would be pitched in the middle of the sort of an 18-month to 2-year YRO. And I'm speculating because it's not my area. I'm not a magistrate, but
no, thank you. After the attack, you've set out in your witness statement from pages 26 to 29 some of the Youth Justice Board's contact with Lancashire CYJS and some of the difficulties in obtaining information from them, even when it was required for the board to carry out its functions, including briefing ministers.
yes.
I don't want to go through that in detail. Can we take it that, from your perspective, it's disappointing that that was the approach taken by Lancashire's Child and Youth Justice Services, not only in the immediate aftermath, but even months later when you were trying to gain information about this case?
Yes, especially as we're not there to make a judgment. We're there to help and to support them to do their best to prevent children offending. So, yes.
Thank you. If I could move now to deal with the issues of knife crime and the availability of weapons, so looking more broadly. In paragraph 169 at page 39 of your statement, you've expressed support for additional restrictions on the purchase of weapons, particularly online purchases.
Yes.
Would you support the licensing of sellers of knives?
Yes, we would support anything that reduces a child's ability to have access to and use a knife.
We've heard evidence about that machetes may be a particular issue, and a particularly common feature of knife-enabled offending. You rightly make the point in your statement that kitchen knives are perhaps the greatest,
Yes.
or used in the highest proportion of those offences. What about a ban on machetes, though?
Would we support a ban on
Yes.
machetes? I find it very hard to see why anyone needs to have a machete. And that's my personal view. I'm not speaking on behalf of the board there. I haven't got that quote from the board, but that's my personal view.
Thank you. There's a proposed new offence in the Crime and Policing Bill of possession of an offensive weapon in private or in public with the intention of using it in or threatening unlawful violence. That's my gloss rather than the exact wording. That addresses what might be seen as a gap in the criminal law in that it covers private places and it doesn't require that someone's already been threatened or harmed. Something that would, again, the board would welcome.
Yes, yes.
I suspect, though, you'd also say that knife crime is not a problem that can simply be legislated
Absolutely
away.
not, no. And you'll have seen that in some of our evidence, our knife crime evidence pack.
Yes.
It is complex and complicated.
YJB 30112, we looked at this before with Mr. Hunt. This is your August 2025 knife crime evidence and insights pack. Who's the audience for this?
So the audience...
Sorry, 112. Sorry.
The audience is anyone who works with children who would want to prevent children causing harm. So that could be, head teachers, youth justice services, youth workers, third sector agencies. We think it is so important that we operationalise the evidence around what we know, because there is a really strong body of evidence.
That was the point I was going to pick up, because that focus on the evidence, does that point... This can, of course, be a highly emotional and sometimes highly politicised issue, but there is an evidence base for what strategies and interventions are likely to have the most effect.
That's right, yes. And we will only make recommendations and comments on the evidence base.
There's a project called Better Outcomes Through Linked Data.
Yes.
Is that part of building the evidence base, deepening it?
Yes, and being able to better understand the needs of the cohort of children. So working across government to be able to link data together so that we can make sure that we are working with those that are most vulnerable, most likely to cause harm, and making sure that resources are targeted in the best way.
And when it comes then to putting evidence-based strategies into effect, you as the board can provide guidance for the youth justice services, but do we come back again to this issue of needing national multi-agency leadership?
Yes, absolutely, and we can give guidance beyond because the evidence base is not just uniquely for those that are in youth justice services, although we go back to the point that a youth justice service is a collection of staff and skilled professionals from those 5 statutory partners.
And broadening matters out from purely knife crime to deal with the question of online harms and the influence of online material. The Youth Endowment Fund, who you've mentioned, I think have done some work in this area. We have one of their reports at YJB 30123.
Yes.
Extracting some of the headline statistics from that, 70% of children have seen real-world violence on social media, 35% of 13 to 17-year-olds have seen children carrying, promoting or using weapons online, 39% say that seeing violence and weapons on social media makes them more likely to carry a weapon themselves. It's pages 9 and 10 of this report. They're shocking statistics.
Absolutely, yes.
We heard yesterday from DCIT about the Online Safety Act. That ought to mean that children are less likely to stumble across violent content or content that promotes or glorifies weapons online. Probably at the moment too early to say what the effect of that has been. Yes,
absolutely. I think that this is still an area that needs, again, more evidence and more research so that we can understand the impact that seeing those things has on children. And I think that the only comment I would add that also goes beyond online violence, but actual real violence as well, particularly for children who may be living in domestic settings. Sorry, and by that I mean abuse within domestic violence within the home. I wasn't very clear, sorry.
No, understood, thank you. When a child comes into contact with the youth justice system, is there scope, for example, under a YRO or even under a referral order, for their online activity to be controlled or monitored?
That's a good question. I would need to take that away, but I can't see why not. I don't see why it wouldn't be, for a referral order, why a panel members couldn't say, your parents will check your browser X. I don't see why that couldn't be. Because
particularly where there is a link between the offending and online behaviour or online material, that might be a significant aspect that needed to be addressed through preventative work.
Yes, absolutely, yes. And we know that, hurt people. So if you're watching other people be hurt, what does that then do to how you think about the concept of violence and harming others?
I was going to ask if the Youth Justice Board had produced any guidance on this, but I think I will have to ask you to come back on that question.
Thank you.
My last topic then is preventative orders, and we have an example being introduced of youth diversion orders in relation to terrorist activity. But there are obviously a number of preventative orders that can apply to children and young people already on the statute books. Injunctions to reduce gang violence, antisocial behaviour injunctions, sexual risk orders, and so on. You deal with youth diversion orders, page 43 of your witness statement and onwards, paragraph 183. I hope I don't do you a disservice by saying that it appears that you are somewhat sceptical of the preventative orders in relation to children.
Yeah.
Can you just help us with why?
There is an evidence base to show that those orders change behaviour and prevent offending or harm.
What do they do instead, in your view?
They actually criminalise children and increase risk and likelihood of harm. So they create a criminal identity rather than a pro-social identity, which is what we would want to achieve with children.
At paragraph 185, you set out what, in your view, would be required to make youth diversion orders as effective as they could be. Do we need to read that subject to your overall view that you've just very clearly explained? No,
I mean, that is our view, is that there needs to be a multi-agency assessment, and keeps coming back to the point I've brought into my evidence.
If I can summarise then that would be careful tailoring to the circumstances of the individual child, proper multi-agency consultation prior to the order being imposed, and effective and again tailored management of the order once it has been imposed. All of those necessary to make the order as effective as it could be.
Yes, and absolutely coming from a safeguarding perspective. You know, really thinking about how you protect the child, because it will be, you know, more often than not adults that are allowing them to have access to the information that they shouldn't.
The risk is otherwise you simply set up a child to fail.
Absolutely, yes.
What about cases where there might be a very high risk from a child, but they haven't yet committed an offence, and so conventional policing powers aren't available?
Yes.
In those sorts of situations, might there be, in some cases it may be possible for agencies such as mental health or prevention and diversion within CYJS to intervene, yes, to try to move matters onto a different course. But equally, that the individual may simply not want to engage in that. In those sorts of narrow circumstances, and obviously subject to suitable and sufficient safeguards, would you accept that there is a role for imposing restrictions on an individual even though they've not yet stepped outside the criminal law?
In the most exceptional circumstances where there is evidence and everything else has been tried beforehand. So where, you know, you have worked through the range of, and I think this is a gap in terms of, I think as I've heard from the evidence, children's social care saying our role is to think about the risk to the child rather than risk to anyone else. And I think that is a gap that does need to be bridged. You know, there is an option of a deprivation of liberty order, although deprivation of liberty orders, a requirement is the child has to be at risk themselves, although fundamentally you could say, you know, they are at risk if they are putting themselves in those high-risk situations of carrying weapons and wanting to cause harm.
Slightly tortuous, that, isn't it?
It is, yes. And very and overly punitive, which is why I think there is a gap, because there could be something which would be much more engaging and preventative for both preventing the child from offending and preventing harm to others.
We come back then to the idea we discussed earlier of a sort of escalation intervention with holistic, potentially trauma-informed support,
yes,
but potentially in a context where it isn't voluntary.
Yes, there's a requirement, yeah.
You've set out some very broad recommendations. If we could go back to page 2 of your witness statement, and just have that on screen. You've set out some very broad recommendations there. I think that's notwithstanding not having been, and it's not a criticism, not having been involved in the other learning processes that followed after this tragic event. Can you help us, given the emphasis on evidence-based
Yes.
policy making, what was the process by which you reached these recommendations?
So this is based on, 20 odd years of existence as an organisation and developing the evidence base. They are only evidence-based recommendations. If it would be helpful, we could take away an action to break them down about how they could be delivered and achieved and by whom, if that would be helpful.
I'm sure it would. I think fair to characterise the Youth Justice Board's view as being that these are urgent matters.
Yes, yes.
You would, I think, also agree that it's important to take the time to get them right.
Yeah. And we could probably, in that assessment say which ones are the most urgent and need to be prioritised and which ones need money and legislation.
And again, it may be that this broader landscape is a topic that the inquiry returns to in phase 2 of its evidence. Before I see if anyone else has any questions for you, Ms Roberts-Bibby, do you have anything else you would like to add?
I cannot stress enough the need for local partnerships to work collaboratively and effectively together, and for that to be overseen in the right way across a system which is locally devolved, where there is local accountability through those senior leaders of those statutory partners, and then making sure that there is enough guidance, evidence-based guidance that is applied consistently, which means that children, wherever they live in England and Wales, have the same offer and the same services to prevent harm being caused to anyone else.
Thank you.
Yes, Mr. Chapman.
Could I ask about reoffending rates, please?
Yes.
Reoffending rates during the currency of a referral order, do you know what they are roughly? What's your impression?
For this year or for previous year, sorry, I can give you.
I'm asking generally, I imagine they're pretty similar over time, are they not?
So overall reoffending rate's 32.2%.
During the currency of a referral order?
So there's, and then that's for all outcomes, which ranges from just over 20% for youth cautions, 30% for those first tier interventions, so youth referral order, ROs, and then 59.9% for youth referral orders, and just over 60% for custody.
I think I'm asking something much simpler, really,
Okay,
which is
sorry.
Once a referral order is imposed,
Yes.
and it's time limited up to 12 months, how many of those offend during that period?
In that 12, the reoffending rates are based on a longer period of reoffending, so it's a 2-year period.
So you don't have statistics for...
No, I would have to, that will come.
Would it be fair to say that once the referral order ends, the risk of reoffending goes up?
I think that's going to depend on each child and what they then have got in place. So, for instance, if you're talking about a child who may have, in this instance AR, who may have been isolated, socially disengaged, actually what you would have wanted through the referral order is to address those issues. You would have wanted to have got to a position where they are, take the pandemic aside.
Let me just stop you there, because I'm asking for an overall statistic.
Yeah.
And we heard from Ms Callan that the rate of reoffending following a referral order in the next 12 months was about 19%. So I was interested in the comparison between that figure
Yes.
and the figure within the currency of the referral order.
Within the, sorry, the currency. I
So
don't
during the
understand
period
your
of the
question, sorry.
during the period of the referral order,
Yes.
how many of those reoffend compared to those who reoffend after it ends?
So you want to know those that reoffend whilst on the order.
Compared to...
I can take that away and see if we've got that for you.
I'd be grateful. Thank you.
Yeah, I'm not guaranteeing we have, but I'll ask our data team.
I mean, my suggestion to you is that it goes up quite sharply, but can you answer that?
I can't answer that now, but I will commit to see if we can answer that for you.
You refer to the Knife Crime and Insights Pack in your statement to paragraph 144. Focused deterrence, what is that, please?
Focused deterrence is when there is activity in a particular area that would help to prevent violence or knife carrying.
What's the deterrence aspect of it?
So you may have high levels of policing. You may have activity where there's targeted searching, so stop and search, for instance. So it is seen as deterring children from, or indeed adults.
Would it also include a swift and effective enforcement?
So if there was an offence, that it would be expedited?
Yeah.
Yes, yes.
And is that been, am I right in saying that that insight pack suggests that where the risk is very high, that swift and certain enforcement is quite effective?
No, it's not necessarily enforcement, it's responding. And they're two different things.
Okay, so responding, tell me the difference.
So responding is responding to the needs. Children carry knives ordinarily because they don't feel safe, or they're being made to. That's what the evidence tells us, and that is clear in the evidence pack. So it is responding to why that child is feeling the need to carry that knife.
What about a child who carries a knife in an offensive capacity? That would be different, wouldn't it?
Yes, which talks to our point earlier, and I was saying about reviewing whether referral orders are appropriate for children where there's an intent.
But where a child is carrying a knife with offensive intent, I'm suggesting that swift and certain enforcement, including criminal sanction, is an effective response, is it not?
That's not what our current evidence tells us.
All right, thank you.
Yes, Mr. Timken.
Thank you, sir. Good morning. I ask questions on behalf of the families of the surviving children. You've said that a referral order should be both inspirational and aspirational for that child. And you've said that the youth offending team worker should be relentless in engaging with the child.
Yes.
And you've said that the worker should show that they're going to hold the child to account.
Yes.
I want to focus, but only briefly, on the latter stages of AR's referral order. You'll know that the records show that at that stage, AR told his youth offending team worker that he wouldn't take a knife to school again. You've seen that in the records?
I have seen that, yes, I have, yes.
And the records also show that AR's father told the youth offending team worker that AR was, quote, a good boy.
Yes.
So the reference for this is LCC 000454 at page 4.
Thank you very much.
And both of AR's parents were spoken to, and they said that they had no further concerns about AR and his behaviour.
Yes.
And accordingly, is this right? For the final 3 months of AR's referral order, contact was then reduced from once a week to once a month.
Yes.
Was that appropriate?
I think I answered this earlier. I think at that point where there was information available that there was an increase in risk, I would have expected to see an increase in contact.
Yes.
And an increase in accountability as well, and trying to really understand why there was a reluctance to engage.
Is there a risk that youth offending team workers might take assertions made by the child or by the child's parents at face value?
That shouldn't be the case, because that's why you have a multidisciplinary team. And you should always be mindful of the objective of the service is to prevent a child offending, not to necessarily take everything they say as being 100% and do some competitive analysis around the information that you've got. So checking it out and saying, I've seen this, what are you seeing when your engagement with the family, what is happening, what does that look like?
But there must be at least a risk of any such comments being taken at face value.
I think there's a risk with any professional being taken at face value, and that's why as a professional you have to use your skills, experience and expertise in analysing all the information available to you as objectively as possible.
And when an order is coming to an end, might there be a risk that an intelligent child will give the expected answers?
Yes, yeah.
To pave the way for a positive assessment at the end of the order?
Yes, although you could say that right the way from the start as well. An intelligent child can give you the answers that you would want. Yeah.
We know that the risk assessment was downgraded from medium to low. I'm not going to go over that again. But finally this, we know that AR was a child with complex needs. And you've said in your statement that such a child needs, on a referral order, concentrated intervention. Is it your view that AR received anything like concentrated intervention on his referral order?
That wasn't what I saw in terms of my understanding. Now, of course, I haven't seen the final plan, but as I understood it, the 3 half-an-hour sessions does not, in my view, equate to concentrated support.
And does that mean that you would conclude that the youth offending team workers were not, to use that word, were not relentless in their engagement with AR?
From what I've seen, I didn't consider anyone to be relentless in their engagement. Sadly.
Thank you very much. Thank you, sir.
Thank you very much. Nearly finished.
It's okay.
One of the things that you dealt with earlier on was with somebody who presents with the kind of concerns that AR did, particularly based on knife crime and a real threat to use a knife. You talked about the need for a multi-agency approach, the need for there to be somebody who owns the risk, there needs to be a lead worker, and there needs to be sharing of information. Now, am I right in identifying as a potential flaw as things stand presently, is that although we've heard a lot about the need for a multi-agency approach, this is, as it were, presently entirely unstructured and is dependent on agencies collaborating together when you're dealing with somebody like AR?
Yes. Well, no, if there is a justice intervention and an order from the court.
But here there isn't.
But prior to any offence being committed, it feels as though that is definitely a gap.
Yeah.
Because I think you could say, well, children's social care have a role to play in terms of safeguarding the child, but I think from all of the evidence that you've heard, I think there's a view that they say that that is limited to the child rather than risk to others.
And the police would say he hasn't committed an offence, so what are we supposed to do with somebody who may have the intention of committing a very serious offence in the future, but they haven't actually done anything?
No.
And here as well, there was an absence of a relevant mental health diagnosis. Absolutely, that would have meant that mental health services should have been the lead. And so for somebody like AR, although people may attend meetings, there would be a resistance to say that I'm the person or my organisation is the body that should take responsibility.
Yeah.
Although you have, if I may say so completely accurately, suggested that information needs to be shared between professionals and that there either is or ought to be the capacity to do that. At paragraph 26 of your statement, you've set out in very clear terms the unsatisfactory nature of the present state of information technology in terms of recording and sharing.
Yes.
And am I right in thinking you see this as being a fundamental problem in terms of securing the right outcomes in cases such as the present?
Yes, because without the right information, you aren't able to then make an informed assessment of risk. And I'm speechless at how much information was available in an uncoordinated, scattered way. That means that there were several opportunities that weren't grabbed.
Are you aware of any department, any organisation, any agency that is currently taking the lead in terms of seeking to address the current parlous state of the IT system, which doesn't facilitate the free flow of information in the way that should exist?
I know that Department of Education have been looking at a unique child identifier to help improve information flows, but that feels more like an add-on than a fundamental review of what's needed in terms of the infrastructure and then how you can use that to get access to the information that you need.
And am I right in also thinking that if information was properly shared in a way that information can be processed intelligently, that would feed into the risk assessment tool which you were discussing with Mr. Goss?
Yes, it would.
And if information could be fed into that risk assessment tool on either an automatic or a semi-automatic basis, it would facilitate the assessment being kept up to date.
Yes, because you could review it. It would almost trigger if you put in an entry that says, in the instance that Mr. Goss gave, that AR had assaulted his father, it could almost trigger a review for you. I mean, there's so much clever stuff that can be done now.
That could be automated, couldn't it?
Yes.
I mean, it needs a human being to look at it to make sure that it is dealing with the information correctly.
Yes.
But the alerts that it sends out could be done automatically.
Yeah, there's so much that could be done. And if you, at the moment, if you are working in a youth justice service with a child, there are at least, I think, 5 different systems that you are navigating around.
Yeah. Sorry, but one final...
No, don't apologise.
AR had the one conviction that he accrued during the course of the time that we've been looking at him. He had made multiple statements that and had behaved in a way that indicated that he wanted at the least to cause really serious bodily harm to another. Given that he had been sentenced for a previous offence, but his intentions did not constitute a further criminal offence, given the high level of risk that we ex post facto now know that he posed, for someone like that, do you agree that there should be an order that doesn't take away their liberty, but which imposes the least necessary restrictions so as to try to ensure that, for instance, he's not able to get into a minicab that he has ordered to go to a school carrying a knife so that he can attack others?
Yes. And that threshold needs to have made sure that all of the other things have been done first.
Yeah.
So appropriate information gathering, effective triangulation of risk to develop an agreed risk assessment and position with a robust plan that is going to then address that risk. And then, as I was saying earlier, an escalation point that if that isn't working, that you then know what you're going to do next. and that all professionals working with that individual are clear on who's leading that, and then what the line in the sand is when you then want to get to that point that, you know, we have done everything here possible to prevent harm. We feel that we can no longer do that, and this is then the option.
And I completely take your point that one has to be careful not to create something that turns out to be utterly counterproductive. I think there is a line of thought that, for instance, sentences of imprisonment for public protection, formulated for the best possible reasons, have had potentially precisely that effect.
Absolutely.
And one could see that having an order of this kind available might lead to a far wider cohort than one had intended being caught by it. But with appropriate restrictions, with all of the things that you've indicated, not something to be recommended now necessarily, but for further consideration, that process is something you would support.
Yes, and I wonder, looking at the rapid increase of deprivation of liberty orders for children, how many of those are being used for the intent as per the criteria. And there would be some really interesting analysis, I think, done there to actually, is this about risk to child or risk to others? And I'm speculating because I've not done any of that analysis, but I think that would be part of that in informing a review about whether that would be the right next steps.
You made, I think, a foolish offer to expand upon the recommendations that you've made at the end. Can I take you up on that?
Of course, yes, we are happy to help in any way that we can.
That has been extremely helpful evidence. Thank you very much indeed. You're now free to go.
Thank you.
We're on exactly the hour and a half point.
We are. Before you rise, sir,
yes.
Could I just put on record that, again, overnight, there will be the summary of further Lancashire County Council evidence placed onto the website. Again, I'm not going to read that out now, given the pressures on time. Could I invite you, sir, to rise for 20 minutes so that the necessary arrangements can be made for our next witness?
Certainly. I'll sit again at 10:02. Mr. Moss.
Thanks, sir. Can I just check that you can see and hear me?
I can, thank you.
Thank you. I think you've got the words now of the oath, and I know that you prefer to swear on the Bible. Could I just ask you to take the oath? You can remain seated for that because you're giving evidence remotely.
Okay, let me I have the words here. Do you need me to hold it up? Is that the best way to do it?
That's fine.
Okay. I swear by Almighty God that evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. We'll try to adjust the volume as necessary, but just keep your voice nice and loud and clear if you would. Just start by giving us, please, your full name.
Deanna Romina Canoniscio.
Thank you. Ms. Canoniscio, if we could have on screen, please, XIUC 4030. Can you just confirm for us that this is your statement to the inquiry, which is dated the 19th of September of this year?
It is.
And are the contents of that statement true to the best of your knowledge and belief?
They are.
Thank you. You tell us in that statement that you joined X in December of last year as the head of global government affairs. Is that right?
That is correct.
Could you give us just a brief thumbnail sketch of the sort of career and roles that you'd had before that?
Of course. Prior to joining X, I spent 10 years at a U.S. Fortune 100 company in a very similar role in government affairs. I started with the primarily U.S. state and local, as well as federal engagement, enhanced my career to do international, lived in Europe for about 3 years in Brussels, actually, in a role that oversaw our engagement at that previous company in Europe, Middle East, Africa, and India. and returned, I want to say it was over a year and a half ago, to the States before joining X.
Thank you. And again, just an overview, can you tell us what the role of Global Government Affairs head actually entails on a day-to-day basis?
Sure. I have a team of people that live in many of the major markets where we operate as a company. And my team and I engage with government leaders, policy leaders, regulators, all types of external stakeholders representing X in government. Many times we are working on policies that are being proposed. Sometimes we're supporting the compliance team on complying with regulations that are being enforced.
I'm just going to ask you to pause there to see if we can get the volume adjusted. You've gone very quiet, so just pause for a moment. So I think you were saying that at many times you're working on policies that are being proposed. Sometimes you're supporting the compliance team on complying with regulations that are being enforced. Is that right?
That is correct.
And does an element of your team's work involving lobbying and seeking to influence the direction of legislative changes in different countries?
It is, yes.
Thank you. Just give us a sense of it. What's the size of your team who work in this area worldwide?
We have about 15 people right now.
Thank you. I want to turn just briefly to X's corporate structure. I can do it relatively briefly. As an organization, X needs little introduction. It's a worldwide leading brand, one of the largest social media companies in the world, obviously. Just give us an idea of roughly how many UK users it currently has.
There are total, I would say, probably approximately 43 million UK users. Probably 198, around 198,000 of them are under 18. In comparison to global users, I would say we have approximately 600 million global users.
Thank you. And no doubt one of the challenges is the different regulations in different countries with which you have to comply, which will be fast-moving every day, every week, I'm sure, a different country changing its regulations or contemplating doing so. Would that be fair?
That is very fair, yes.
In terms of concepts, if we could look at page 2 of your statement, please, in paragraph 4. You explain that users can engage in public conversations, can post material, or interact with each other's material and see news. Again, to many that will be very familiar, but that's the essence of it in terms of what it offers online. Would you agree?
Agree.
And then you deal with the fact in paragraph 3, looking at the legal technicalities of it, that X Internet Unlimited Company is a company registered in Ireland that provides the X platform for users who live in both the European Union, EFTA states, and the United Kingdom. Is that correct?
That is correct.
And the US company, X Corp, provides the X service. Is that elsewhere in the whole world?
That is correct. I believe so, yes.
Thank you. Sticking with paragraph 4 in terms of now looking at the importance that X ascribes to the freedom of speech, you say in this paragraph that you aim to support and encourage freedom of expression and a diverse range of views, even those that may be controversial or unpopular. Is that right? That
is correct.
You use a phrase in paragraph 4 that X is a quote-unquote global digital town square. What's really meant by that in plain English?
Well, when you think about the platform in and of itself, and as I stated in my witness statement, it aspires to give an equal voice to all people within the bounds of the laws of the country by which we operate. It's where we encourage people to come together and have conversations globally about what it is that may be occurring, whether it's issues that they're dealing with locally in their own town, all the way to global issues that we may be facing as people all over the world. The key here is that our goal is to give people the ability to be ultimately truth-seeking and find what it is that is actually happening in the world and have a conversation about that. We understand that that can be very messy and uncomfortable, and many times it can be controversial. But it is important to us to be able to provide that platform so that the truth is found, the truth is sought, and then there's a global conversation about it. And that should be across all borders. It should be across all types of people. It's encouraging diversity of thought, diversity of perspective, diversity of culture, because we believe ultimately that is the way by which humanity will move forward.
Thank you. And I want to come on to explore with you the difficult boundaries when you get into violent conduct and how those judgments are drawn. But if we look at ILT 4078, and if you'll forgive me, there's kind of an issue from showing your own X page. ILT 4078, please, Sarah. The banner that you have is free speech more important than your feelings. And I apologize in a way for bringing that up when it's your individual page, but presumably, given the seniority of your role, that's emblematic of, would this be fair, the importance that X Corp and places on freedom of speech and its importance.
It absolutely does, and one of the main reasons for me joining X Corp in this position is because of their position and the direction by which the platform believes that freedom of speech is ultimately the power of humanity and evolution as we continue to grow as people across markets, as people across different cultures, and an understanding of the world as we see it.
And so ILT 4079, in similar vein, I think, was this upon your appointment or shortly thereafter, you were thanking another senior member of X for trusting in you to be what you described as your free speech warrior. Would that be fair?
That is very fair. And if I may take just a minute to give you an example for why I am so passionate about that free speech mission. I come from, my parents are immigrants and have left part of the world that restricted our ability to worship and censored our ability to communicate within our belief system. And when they left the countries that we've come from, they were looking for countries that are going to give us that freedom. Luckily, places like the UK and Australia and the US and Canada were safe havens for people from my community. And being in the US and preserving that right, really being in any of these countries that have offered that safe haven to so many that are looking for a place to have that freedom of religion and freedom of speech, is probably the most essential thing that I could do moving forward so that I'm protecting it for others that are going to be able to need it. Because if we lose it in our countries, we have nowhere to go.
And if the government of one of those Western liberal democracies that you mentioned, including the UK, in correspondence with X, indicates that it has a concern that a line has been crossed in the difficult balance, is that something that X takes seriously?
Of course, we will always be open to that dialogue. We will always be open to understanding what position the government is taking. We will work within the boundaries of your laws, and we will honor that in order to be in compliance, because we have to operate within those laws in order for us to provide this service to the people. Where you will see friction and where you will probably hear friction that is reported consistently is when we believe governments have gone beyond what is written in law, when we feel like they are overstepping what are in the bounds of that law. In those situations, we will publicly and sometimes legally challenge within the bounds of the law of that country that decision or that request that's coming from the government.
Now, I think you do, however, as a company, recognize that there must be boundaries to free speech, not just by the law, but in terms of policies that you have on the platform in relation to matters such as violent material. Yes, judgments have to be made.
Judgments do need to be made, but those judgments are not for ex-employees or X as a company to make judgments.
Well, I think to an extent you must accept that they are, because you have a policy about material which doesn't define the material solely by definition of whether it's illegal. So, for example, if it's excessively gory, we'll come on to look at the detail, but you have a policy that says certain matters are prohibited, including violent material that's excessively gory. So there are judgment calls made, in fact, in truth, are they not, by ex-employees, because you'll look at that to see whether it violates the policy.
Well, the policies are based on a global understanding of laws and rules that are applied across multiple different jurisdictions. So they're not made necessarily by ex-employees, but a collectiveness of humanity, right? And so to say that we make that judgment as individuals is not necessarily accurate. It is a collection of laws and rules that governments have set in place that we have baselines for.
All right, so you have baselines based upon a collective understanding of laws across the world without picking any individual law. Is that how the threshold is set?
That's what we strive for. It's not a perfect science, but that's certainly what we strive for.
And you say in your paragraph 4 that you don't tolerate behaviour that harasses, threatens or intimidates others in order to silence their voices.
Correct.
On one view, that's plain and straightforward. Does it have to be behaviour which harasses, threatens or intimidates others in order to silence their voices? Surely behaviour which harasses, threatens or intimidates for any purpose is at risk of crossing the threshold.
I mean, I think it's a case-by-case basis. The most important thing we look for is context and intent in those discussions. Many times, just like when you're sitting around the table, having a discussion about something that's controversial with your friends or family, people say things that maybe they don't necessarily mean in the heat of the moment, but you take into context and the intent of the individual. We try very hard to make sure that we are not over-censoring that level of dialogue. Now, what we focus on is direct threats, situations by which we feel as if that it has gone beyond that civil dialogue. And so it's not, like I said, it's not always a perfect science, but we will almost always lean where we can towards allowing people to have that free speech over censorship.
You have terms of service, which are rules that the users must agree to, I think.
We do.
And if we look at ILT 4080, this was in, I think, a different context of evidence that's been given on a different occasion in a different forum elsewhere. But we can certainly see from this X post that the company certainly purports to recognise the importance of protecting children online. Yes?
This is true. Yes.
And if we could take that down from the screen, please, and look at the concluding statement in your paragraph in your statement, paragraph 44, please. It's page 15, Sarah. Page 15, paragraph 41. X is committed to ensuring that its young users are protected from age inappropriate and sensitive content online and that violent and terrorist content is removed or otherwise treated appropriately. Yes?
Correct.
Thank you. So would this be fair at a high level of generality that you do recognise that a balance needs to be struck? I'm going to concentrate on violent material, but as a company, you err quite towards the freedom of speech line in relation to that and where you set the threshold as a company.
We do err towards freedom of speech, yes.
I want to turn briefly to the regulatory position in the UK. We heard from a witness from the Department of Science, Innovation and Technology here in the UK, Ms. Connolly, yesterday. And I think it's only fair that we just get the chronology straight in relation to when AR's attack occurred. So Ofcom's illegal content codes and child safety codes arising from the Online Safety Act had not come into force by July 2024. And so for X, the Online Safety Act had not come into effect insofar as X was concerned. Would you agree that that's a fair summary?
That is a fair summary, yes.
And given that X was not based in the UK, it was not directly subject to the various pieces of regulation that existed at that time, that's the evidence that we heard yesterday. So our domestic laws on, for example, video sharing platforms, I don't think directly applied to ex-IUC. Is that correct?
That's correct.
And Ms. Connolly told this inquiry yesterday that as a result of that, at the time of July 24 and in the years prior to that, the decision as to whether content should have been available online, both to adults and children, was a matter really for social media platforms to take in line with their terms of service. Would you agree with that?
That is correct.
Thank you. The exception being that if the content was illegal and its existence was brought to your attention as a platform, you risked being liable if you didn't then remove content expeditiously, which had been drawn to your attention as being illegal.
If it was drawn to our attention as being illegal, then we would have addressed it under those legal rules for that country, correct?
Thank you. I'm going to turn to some of your terms of service and other policies. The X terms of service for both 2024 and now you've provided, so I don't need to turn them up, but could I just give you the references? It's X-IUC 502 and 503, respectively.
Thank you.
But I think you can agree that the terms of service include a requirement for users to abide by the acceptable use terms, and notes that X has broad enforcement rights and states that users should only provide content which complies with applicable laws, rules and regulations, yes?
Yes.
So in terms of the terms of service, for reasons that we can probably all understand, I think it's fairly high level, but you then have, sitting below that, rules and policy on content which you require your users to follow. Would that be a fair summary?
Yes.
Thank you. And those policies include policies on whether or not X will take enforcement action against a post, is that right?
That is correct.
And if we can look at paragraph 19 of your statement, please, on page 8. Again, just drawing out the framework that you set. You explain that in making judgments, that you consider that context is important. I'm looking at the third line in your paragraph 19.
That is correct.
Just briefly, it may be obvious, but why is weight placed on the context?
Well, I mean, I think I explained that just a little before. It's context and even intent to some degree, because again, in order to really understand whether somebody is being violative is really to understand whether the conversation that's occurring is of violative nature or is it a conversation on a controversial topic, which in many times can be very emotional. And so the context by which the conversation is occurring is valuable in order to ensure that we're not over-censoring that level of discussion and thought that is occurring on the platform.
And so to take a simplistic example, if there was a crime that was filmed, you might take a different view of whether the post was saying how awful it was and how action needed to be taken, from if the post was somehow glorifying or inciting or encouraging that which had happened, to take an extreme and simplified example. But
that is a great example, yes.
I follow. And then in paragraph 19, a little bit further on, you give some detail in this of the factors that might be considered, whether the behaviour is targeted at an individual or group or a protected category of people, whether the report has been filed by the target of the abuse or by a bystander, whether the reported user had a history of violating Axis policies, the severity of the violation, and whether the content in question is a topic of legitimate public interest. So they're the sort of contextual factors that as an organisation you would look at if a post of concern was brought to your attention and you had to exercise the judgment call on whether it's taken down.
That is correct.
Thank you. In paragraph 20, you say that consistent with the enforcement philosophy, some content depicting violence, and I'm going to come back to the Bishop Emmanuel attack later, but may remain on the platform if it is associated with newsworthy events to raise awareness or call for political action, provided it is properly labelled with a content warning. Should we understand from that even very graphically violent material might be permitted to remain on X if the contextual assessment is that it's a newsworthy event or raising awareness or calling for political action?
There is a possibility that would occur, but it would also be labeled accordingly. So it wouldn't just be freely out there. The goal is to label that accordingly if it's graphic content.
Thank you. And then in paragraph 21, you set out the range of different policies. And I say I'm going to turn to the detail of some of those in a moment, Ms. Kananishi. So for the moment, I'll just highlight the headlines. So violent content policy, the violent and hateful entities policy, and then over the page, please, Sarah, the perpetrators of violent attacks policy, the hateful conduct policy, and the abuse and harassment policy. Now, not all of those are relevant, but it's only fair that I should draw out that you have that range of policies in place to try to navigate these threshold decisions of what's prohibited, what's allowed with a content warning, and what's allowed without a content warning.
That is correct. In addition to just warnings, I should point that depending on the policy and its reach, or its, I guess you can say, management or how we flag it, it also restricts certain uses. And so as an example, if something is marked as sensitive, somebody that is underage is not able to access that policy. So the policy isn't just about flagging it and making sure people understand it, but it also restricts seeing it and its reach and its potential access to users.
It's right and fair you pointed out, but rest assured I'm going to come to age policies in
I just want to make sure.
No, okay. It's relevant context. Thank you. It's also right that I should just draw out that in paragraph 23 at the bottom of the page, that you were keen, I think, to make clear in your statement that in terms of terrorist activity, that X has participated in key international initiatives worldwide, and you list them. The European Union Internet Forum, over the page, X is a founding member of the Global Internet Forum to Counter Terrorism. Christchurch Call to Action, I think, is the third example that you give. So you would be keen, as I've understood it, for the inquiry to be aware that you consider as a company that you're proactive in the counter-terrorism sphere in terms of tackling terrorist material being peddled online.
That is correct.
Thank you. Now, as I promised I would, I want to turn to look at age requirements. And we'll come on to changes introduced in the Online Safety Act after the date of the attack with which this inquiry is concerned a little bit later. Let's look at the position as it was at the time of the attack in July 24. The requirement by X as a matter of policy is this right, was that users had to be at least 13 years old in order to create an account?
Correct.
And does that remain the position now?
It does.
And if we could look at page 4 of your statement, at paragraph 13. At the time in the UK, you would require, is this right, all users who want to create an account to enter a date of birth?
That is correct.
And users who entered a date of birth that indicated they were over 13 but under 18 were allowed to create what I think of as a child's account, but the effect of that, as you mentioned a moment ago, would that account would not allow access to sensitive material.
That is correct. There are certain restrictions that come automatically when an individual is under the age of 18.
Thank you. And that included, I think, violent material.
That does.
Thank you. Before we come back to the pure age issue, there are a number of other safety features for children that you set out in your statement. So there were options that could be set, I think, to block unknown users, and there were tools that parents could use to add parental controls, including to restrict their child from viewing certain accounts or certain types of content. I think those were all tools that were available.
That is correct.
Thank you. And that also allowed time limits to be set.
Time limits? Is that what you asked? I'm sorry.
It's paragraph 15.8d, if that helps. Page 7. I think one of the parental control facilities is allows.
Yes, under parental control. Sorry,
yeah,
yes.
To set a time limit.
Yes.
So if the child was engaging with parents and parents were engaging with the child about the use of a child account, there were additional steps that could be taken to keep the time restricted and to make bespoke changes to what type of material and what type of interface you could have with other users to protect the child.
That is correct.
You also had a policy, as you tell us in paragraph 16, to allow the reporting by other users of users who are underage.
That is correct.
All right. Now, all of that was prefaced upon the starting position that in July 24, what was required to open an account was for you to enter the date of birth. And I just want to explore with you whether there were problems with that, perhaps what might be thought to be very obvious problems. Because if all that was required was for the user to enter their date of birth, a 13, 14, 15, 16 or 17-year-old could just enter a false date of birth, presumably.
Presumably, correct.
Well, I say presumably, but there was no further checks done at the time by X. You didn't require ID.
That is correct.
You were trusting that the user, whatever their age might be, would be honest in self-declaring their age.
That is correct.
Was that satisfactory?
At the time it was, yes, and let me explain a little bit why. X is not a platform that is targeted for children. We don't advertise to children. We don't have any offerings to children, and in fact has a very little user base, less than 1% globally, frankly, that is under that age. And so while we absolutely proactively have all of the restrictions by which you have already gone over, from parental controls to all of those things, we have already proactively put all of those positions in place. the measures we apply balance the public's right to access to information with the safety and the proportionality of our users. So yes, that it was appropriate at the time.
But as a company, you were aware that perhaps relative to some other social media platforms, as you've already told us, X, increasingly perhaps over recent years, has erred on the side of freedom of speech, allowing more material, yes?
Exactly, yes.
If a child is interested in violent material, they are therefore going to think that X is a good place to find it, yes?
That would presumably mean that they know that X has that material. And by the usage of how many children or people under 18 are on the platform, it's not as if we're out there advertising that you can come find this on our platform.
I'm not suggesting for a moment that you would be advertising, but can I suggest that a company with the reach, the resources, and the intelligent personnel that X undoubtedly had, it must have been obvious that it was literally child's play for a child to bypass the age requirement, because all they had to do was lie and put in a false date of birth.
I mean, to say that if a child is advanced enough and seeking violent content and they want to lie about their account, that's a pretty advanced thinking child or somebody that is under 18 years old. And frankly, it wouldn't matter how many protections we have in place. At the end of the day, if somebody is that determined to find the content, they would find the content on any platform.
Do you not recognize any sense as the owners and distributors of the platform material for a sense of social responsibility to take a part in seeking to avoid that behavior? Because we're going to look at AR's case, and I'll be suggesting that that is exactly what AR did in relation to X. So do you see a degree of social responsibility ought to come into that to make it more difficult for children to simply say, well, I'll pretend I'm 18 or 19 and I'll look at whatever I want?
Well, I think we have to always balance the social responsibility with the individual's right to free speech and overreach by government by censoring
But why,
people. So
why is
that's always a balance that we are going to address.
But why is it an interference with free speech just to require somebody to prove that they're over the age of 18 when you as a platform already recognize the importance of protecting children from inappropriate sensitive content? I showed you the tweet earlier on in which X was understandably lauding the role that it takes in child protection. Why not back that up in 2024 with sensible measures to just ensure that users signing up were over the age of 18?
Well, when you have 600 million users globally accessing the platform, to require each one of them to say put in an ID in order to minimize the less than 1% to have access, that in and of itself can be seen as over censorship. That's the first thing. The second thing is it is a privacy concern. People are required to put in their IDs into a data system that then has to be housed by a private company globally, which is not necessarily something most people want to do. And if most people don't want to do that because of their privacy, then that in and of itself also restricts their reach to be able to understand what is happening across the world and their ability to speak it. So introducing frictions like that for the masses when we have a very, very small percentage of children on our platform and we are not advertising to bring children on our platform is actually it's not something that we see as proportionate to our users.
A company with the reach, the resources, and the intelligent personnel, and groundbreaking technology such as X, could have introduced measures to check children's ages if you wanted to do so, even before the Online Safety Act. Would you agree? If you'd wanted to take action, you would have found a way.
Well, we did take action. We were very proactive in putting in frictions for children and for people under the age of 18. And we consistently worked on other pieces of technology and capability to continue to perfect that. At that moment in time, that was what we had in place. But that is not to say that as a company that we wouldn't have continued to find better ways to address the underage issue.
Yeah,
and we have done so over time, including up till today.
But prior to the Online Safety Act, my question was that you as a company, if you'd wanted to do something about this, you could have found a way. Do you agree or not?
That would presume that we didn't have any restrictions in place, which we did. So we did want to find a way, and we did have measures in place to try to protect children.
No. And those measures amounted to the single requirement for the person to enter their date of birth, nothing else.
I mean, I would have to go back and look. I wasn't there in 2024, so I can't distinctively say there was no other measure in place. So I won't make that statement on behalf of the company. If there were other measures in place, I just don't have them in front of me right now.
No, but it's something that you were asked about in your Rule 9 request, and you've set out what they were in paragraph 13. Can we have it back on the screen, please, Sarah, page 4? And I appreciate you're not the only witness to this inquiry, Ms. Kananishi, who's giving corporate evidence on behalf of an organisation who wasn't in post at the time, and we're sympathetic to that difficulty. But no doubt if ex-IUC or ex-Corp had in place measures more than just asking a child to enter their date of birth to create a child account, no doubt that the company would have informed you of it when you were producing your witness statement.
That is correct.
Thank you. Very briefly, I think if you're not logged in at the time, if you are not logged in as an ex-user, if you're not a certified account holder, you're trying to access as a member of the public, I think there are restrictions. You can see some things from X without being a user, but I think sensitive material would be one that you couldn't access without being a registered user.
I believe that's correct. The logged off user, when you find a link, I'm pretty sure that's correct.
Yeah. So a child online who's trying to find X material without an account would in that sense be protected because your systems should at least have detected that it was material that shouldn't be shown to non-registered users. Is that a fair summary?
That's a fair summary.
Thank you. Can I ask in general terms, within the controls that were in place in the summer of 2024, there was, I think, a requirement for users to mark where they had content which might contain matters such as nudity or violence. Can you help us to understand how effective the oversight was of that? If users put up content that was violent but wasn't against the rules, so it wasn't prohibited material, how would X as a platform identify, well, hang on a minute, we're not going to prohibit that post, but that should have a sensitive marker?
I mean, I'm not an enforcement expert, so I'm just going to give you a little bit of the way I understand it works. Is there are several, there's a combination of different steps that's taken by our safety team to include machine learning along with human content moderators in the combination that make those assessments, and then determining what it is that image portrays. There are a certain set of models and triggers by which that is evaluated, and then the content is then flagged under those different, as the policies that you had outlined earlier, along with all that, will flag which of those violations, and then what is the enforcement measure under those violations.
All right, and I don't want to spend too long on this because the evidence suggests that AR did have an account, or a number of accounts in fact, with X. He wasn't trying to access material just as a member of the public who wasn't an X user. But just on that, would it be right that the protection that's offered for sensitive material would only be as good as those enforcement measures in terms of identifying cases where a user had not self-labeled a material as violent or sensitive.
That is correct.
And no doubt, I've got no basis to suggest otherwise, no doubt that is something in which the company invested what you consider to be appropriate resource, but also no doubt it wasn't perfect.
That is correct. And for the record, the company continues to invest in significant resources to continuously improve the enforcement capabilities across the world.
Thank you. I want to turn to the impact of the Online Safety Act just in outline terms. And we've been put on notice, Ms. Kalanishi, that there may be elements in which, if we get into the granular detail, is beyond your personal knowledge. So if you can't answer, and if it's something that needs to be followed up in writing, then you should say so. But
okay.
See if you can assist us. So the Online Safety Act, I think, came into force from the perspective of X when the illegal content risk assessment guidance was published on the 16th of December 2024. You deal with that in paragraph 39. And then in paragraph 40 of your statement, can we just turn that up? It's at page 14. Bottom of the page, please. You say that X is now constructively engaged with Ofcom to ensure its compliance with the OSA, and in relation to the 5 topics on which the inquiry seeks information, and then you've set out the illegal content risk assessment that's been done, and then over page, children's risk assessment, safety duties about illegal content, safety duties protecting children, and the duty about content reporting. So you set out the measures that have been taken in relation to that, and indicate that you, I think, accept that you need to abide by those codes.
Of course, yes.
Yeah. That does mean, as Ms. Connolly was explaining, that you must now have in place systems and processes to mitigate the risks of users encountering illegal material, yes?
Yes.
And now a statutory duty to remove it swiftly once they become aware of its existence on the platform, yeah?
We are to act within accordance of how the law is drafted, yes.
Yeah. And in relation to harmful content, the emphasis is upon taking proportionate measures to protect children from encountering harmful but lawful content. Again, Ms. Connolly summarised that for us yesterday, and you would accept that that's the nature of the duty that X now needs to meet under the OSA.
Yes.
Thank you. Do you know in general terms what the effect has been of the assessments that you've done in relation to children's risk assessment and violent content, matters of that kind? Have the assessments that have been done meant that you've had to be more rigorous on restrictions on the content?
I don't know when it comes to the content, unfortunately, if we've had to take additional steps. My assumption is that the team is still working through that, and they've internally offered solutions to our safety and trust team. If that is absolutely the case, that's happening right now. But I'm not aware, I'm not part of those discussions.
In terms of how that has changed, it might be thought for the good, age verification, you deal with that in paragraph 14, back on page 4 of your statement. And I think
yes.
If we look at paragraph 14.1 together, it will come up on screen. You've got a hard copy, I think, which is fine. But you first of all, I think, look to what you regard as highly reliable signals. So if a user has previously declared that they're under 18, that would be a highly reliable signal. Presumably, that would flag up they're likely to be under 18. That's a signal in one direction.
Right.
Yeah. If a user has previously completed X's ID verification process, so in my words, if they're already cleared, that's a strong signal that it's okay. Would that be fair?
That's fair.
If a user had received a blue verified badge according to the legacy verification policy, would that be because a blue verified badge would have to have effectively shown that they were an adult.
I believe so. There is an ID or a verification by which that you get that badge, including subscription.
Right. And then if the account was created in 2012 or earlier, presumably that's because you take the view that the child would have just been far, far too young at that stage to create an account. So if it's been there for 13 years or so, that they must be an adult.
I believe so.
And then you give some other check marks indicating the represented government or multilateral organization or a verified organization, which perhaps speaks for itself.
Yes.
So that's the first stage of age verification. And I think that thereafter, if the person seeking to create an account doesn't pass that, we get to 14.2, various additional methods to estimate a user's age, including based on the user's email address and social connections. How does the email address help? Can you help us with that?
That's a great question. I don't know, I'm not sure on that one, to be completely honest, and I should have asked that question before coming here. I actually had that written down, so apologies for not having that detail for you.
All right. If that's something that can be provided by way of a top-up explanation, correspondence for that might suffice. And social connections, would that mean that if there's evidence of a lot of interface with adults, that it's thought sufficiently safe to assume that they're an adult as well?
I mean, it's part of it's one of the many pieces of, I guess you could say, a puzzle in trying to identify a person's age without asking for ID. So I don't think in and of itself it's a determining factor, but certainly one of the many that they put together to try to assess that.
Do you have a sense of how robust the measures at 14.2 are? Has there been any auditing of that or testing of it?
I don't know, I'm sorry, that I don't know.
All right, again, that might be something that would be helpful for you to just provide, having checked with colleagues. And then at 14.3, over the page, please, Sarah, it seems that if that isn't effective, so those further checks, then you get into two ways of doing it. I think one is a live selfie, is that right?
That is correct.
Which will be used to estimate their age using AI, and the other is to then produce a government-issued ID. Yes?
Correct.
To some outside observers, it might be thought that it's somewhat telling that the last stage in that is a government-issued ID. Do you remain as a platform somewhat reluctant to ask users to produce a government-issued ID?
I don't know if it's necessarily reluctance or it's not 100% foolproof. I'd have to understand a little bit more the steps by which we're taking. I think at the end of the day, we would prefer to be able to AI and scan and address it that way. I think an ID, as we have known through multiple different ways, IDs can also be falsified. And you can put in your family's ID, you can put in somebody else's ID to get the account that you want. And so maybe the reasoning around that is it's not totally foolproof, and the combination of the two gets us to where we want to go.
Certainly in a slightly different context in this inquiry, in the context of purchasing weapons online, one of the things that's being considered is ID also connected with a live link and a selfie, so that you can see that the person actually does look like how they appear in the government ID. Is that something which X has considered?
I'm not sure. I would have to talk. I've not discussed with the engineers the different methods by which we feel we're going to reach that high probability of success. I'm sure that there are different technologies that they're reviewing to get to that.
All right. Now, you will recall, I'm sure, that a little while back in my questioning, I was challenging you about the ineffectiveness of X's pre-OSA age verification processes. Basically, a child could just lie, put in any date of birth they want, and they get an account. Although our reach only extends to the UK as an inquiry, can I test this just in terms of X's attitude to all of this? In the rest of the world, does it remain the case that all that you need to do to get an X account is to put in a date of birth? Or have you extended the age verification strengthenings of the OSA to the rest of the world?
We have not yet done so. We are looking at different technologies and different solutions in order to continue our journey on the safety mission. It may be that at one point, depending on where other laws are across the world, that we start to implement this type of measure. Because it's so early in the development stage and even in our technological advancement stage, it's not something we're going to do overnight, but it's definitely something we're looking at.
Well, you described that as being part of your journey on a safety mission. When as a company, and I'm going to come back to this later in my questioning, but when as a company you realized that the Southport attacker, 6 minutes before he left home, used X as the platform to search for a very violent video of a terrorist stabbing, did that not hit home about the importance, I'm going to suggest worldwide, to take age verification more seriously, given that at the time AR was a child?
That would make it such that the responsibility and the presumption on X is that we know what the intent of the individual is when they're looking at that video. And we don't know the intent of any individual that is on our user platform for their looking at videos, for reading content, for commenting on content. And so that is not a presumption X should be making. It's not a presumption that we should be making individually. I mean, there are students all over the world that are researching many things. There are researchers all over the world that use our platform to access information. We can't presume that when somebody is looking at a video at any age that their intent is to harm people.
But it's harmful content, it's violent content that right-thinking people might well conclude children shouldn't have access to. That's presumably while you have a child policy in place. So in fact, you don't need to make any assumption about intention. You just need to take socially responsible actions to enforce the age restriction. What do you say about that?
Well, I would say that there were measures in place to restrict and create friction for children to access that content. There were measures and signals and graphic violence notifications on that content. And there was plenty of safety measures in place. The presumption, if we're going to make a presumption, is that he was looking for that content, specifically for that content. And so at that point in time, anybody who is that determined to find content is going to find it and find a way around it. To say that we didn't have any social responsibility in managing it is not accurate.
But
it was sensitively labeled. In order to actually receive it, you have to click past that sensitivity label if you've gotten to it. So he made the decision to do that. And if somebody is that determined to do that, they're likely going to go beyond it or look for it somewhere else. And so we're not going to be in a situation by which we have these presumptions in place that we're going to restrict people's reach and assuming that everybody that looks for this is going to be committing some sort of heinous crime.
No, but you don't need to go that far. And the social responsibility, I would suggest, is simply to take measures to mitigate the risk and to lessen the risk that it's available on your platform, which you as a company do have a responsibility for.
We did, and at that time we believed that the measures that were in place were the ones that were available. Now,
and that method, just to be clear, was trusting a child to put in their date of birth correctly and trusting a child that with a warning about violent content that they wouldn't click on it and see the violent content. That was the sum total.
Well, the assumption is that that child also has oversight by adults and parents to make us wholly responsible for a child's behavior in and of itself as a company without any responsibility that goes for those people that are ultimately responsible for that child is not a fair thing either.
No, Ms. Kennedy, please understand that in terms of AR's family, they'll be giving evidence this week and we'll be asking them about their responsibilities. So the inquiry is looking at it across the piece, and your company is only one piece of that jigsaw, but I have to probe and test how you dealt with your responsibilities as a company. So let's focus in our exchange upon that, if we may. I want to turn then to the Bishop Emmanuel stabbing and the video of it. As you know, but just to introduce the topic, Bishop Emmanuel was stabbed on the 15th of April 2024. I think you would agree that he was seriously injured in the knife attack at the church in Australia, yes?
Yes.
Thank you. It was while he was delivering a sermon at the church in Sydney. And the background to this is that the bishop live streamed his sermons, I think, on YouTube. Yeah?
That's correct. Yep.
And again, I don't want to be accused of overlooking any of the contextual considerations to which you've rightly drawn our attention. It's right that I should draw out that Bishop Emmanuel, in terms of the posting of this, has said himself that he doesn't have any objection to the video remaining available. Do I understand it correctly?
That is correct.
Thank you. The imagery of that attack, and even in introducing it, I perhaps should just give a warning to victim family members listening. But the imagery of that attack, Ms. Kennedy, for reasons I hope you'll understand, is too graphic for me to play as part of these inquiry hearings. It wouldn't be fair to the victims because it may be triggering for them. And we should be careful not to go into too much detail about it, even in giving a verbal description. But would you agree that what the footage shows is the attacker, who was himself a teenager, a child, walking down the aisle, approaching the bishop, and then he goes on to stab him on a number of times, and that is caught on the footage?
What is caught on the footage is an attack. What is not clear on the footage is if there was a weapon used.
Well, you say that, but a weapon was used. It
Correct.
may be that the granularity of the footage doesn't show the knife in question. But if you are sensible about it, you would readily accept that what it shows is the attacker repeatedly moving his arm ferociously in an act of stabbing.
So I actually saw that live, and in watching that live, there is an individual that is walking up to the bishop and attacking him, repeatedly moving his arm over the bishop. There is no indication by which that individual, we did not learn till later that it was an actual stabbing and not a punching or just a straight attack.
Right.
Because that is not actually in the footage.
All right, but come on. We know now that he was stabbed, and I've accepted
Correct.
that you can't see the knife. So I'm not for the moment dealing with the live footage. I'm asking about its retention. Knowing that he was stabbed and knowing that you can see the arm of the attacker repeatedly making a stabbing motion, would you agree that the footage is pretty horrific?
Yes, it is a horrific incident to watch. Absolutely.
And the footage is horrific.
Of course, anybody being attacked in any way is horrific.
Yes, but this footage is horrific.
I've said that
Yeah.
twice now. It is absolutely horrific to watch anybody being attacked under any circumstances.
You hear screams from the congregation and then see them run towards the attacker and Bishop Emmanuel, yes?
Yes.
And subsequently, we know that the bishop lost the sight of one eye, I think, in that attack.
I believe so. I'm not sure if there's still treatment being done, but I believe so, yes.
Now, initially, as you quite fairly point out in your statement, it's paragraph 25, sir, for your note. That was footage that was shared across many websites worldwide, by no means only X, and it would be quite unfair for me to suggest otherwise. So YouTube, Facebook, Instagram, TikTok, Reddit, others, as well as X, I think carried that footage in the immediate aftermath. Yes?
Correct.
The criminal trial has not started, but I think you will now be aware that the young person accused of committing the alleged stabbing faces charges of committing a terrorist act.
Yes.
And that fresh charges have been laid this September of him accessing and sharing violent extremist material as well.
Correct.
So at least on the basis of the Australian authorities, we're dealing with a terrorist motivated attack and a terrorist who's been involved in sharing violent extremist material.
That's my understanding.
Of course, we cannot know, but the sensible outside observer may think that it might not be a coincidence that the attacker chose a sermon that was being live streamed. It would be a reasonable assumption that that was done for the purposes of getting as much notoriety and infamy for the attack as possible.
I can't comment as to why somebody would do something under those circumstances and whether they are looking for notoriety or even if they knew that it was live streamed.
That wouldn't be an unreasonable assumption or proposition.
I don't make assumptions or propositions about anybody's intent to attack somebody else.
No. Thank you. I think before we come to the Australian litigation, I think X continued to host the video, but it was something that was labelled as sensitive content, so it wouldn't have been available for children, assuming that children had honestly self-declared their real age.
Correct.
Thank you. Looking at the policies, please, could we look at XRUC 4013, please? This is the violent content policy for X, as it was at the time, I think. And if we could go, please, to page 3 within that. We see that violent material that depicts graphic, violent or excessively gory content, including sexual violence, is something that is not allowed. Yes?
Correct.
Now, obviously, I don't want to have a protracted debate about the definition of graphic or glory, but this visual media certainly depicted very violent content. Would you agree?
It is violence, yes.
Well, my question was very violent. It is very violent. It shows the act of a stabbing, as we've established.
It is very violent content, yes.
And if we read on, we see that X prohibits violent media that you consider high in severity and likelihood of harm. One assumes, and you'll no doubt be able to explain why in a moment, but one assumes that X came to the view that it didn't meet that threshold. Would that be right?
That is correct.
Would you accept, based on our earlier exchange about the nature of the footage, that at the very least there was an arguable case, one that warranted consideration, that this was footage that depicted graphic and violent material that was high in severity and likelihood of harm? Obviously, you didn't agree with that, but could you see that a sensible outside observer might say, well, there's an arguable case that that threshold is met?
I think any observer, depending on where they come from and what their views are, can look at any attack on any human being under a lens of different levels of violence. And so, yes, we did look at that. There was a dialogue. There was an assessment made.
Ms. Kalanishi, can I ask you to try to focus on the question that I ask and engage with what I'm asking, because we don't need to trouble about attack on any human being and that. I want to focus on this attack, which you've accepted is very violent, which shows the attacker, who's now considered to be a terrorist, repeatedly moving his arm in a stabbing motion. So let's focus on that one.
Okay.
And my question was whether you would accept, as a company, that there's an arguable case that that made this threshold, even if the ultimate decision of X was in a different direction.
There was an arguable case made by the Australians.
No, I'm not coming to the Australians. I'm interested in you as a company, looking
okay,
at your
I'm
own
trying
policies.
to explain that it's pretty clear that there was an arguable case made, and we made our case, and there was an outcome to that case. So yes.
Forgive me, you're completely misunderstanding my question. I'm going to come on to the Australian litigation, but before the Australian government sought to take action in relation to this, you would have had to make a determination yourselves as a company. And I'm not asking here about a legal test or the legal challenge. I'm asking about you as a company making an assessment of whether this violated your policies or not. So in that context, did you have internal debate? For example, my paraphrase, but this is a difficult case. It's close to the line, but we think that in the context, it's probably okay.
So yes, in the context, in the discussion, there were several factors that were looked at in order to make a determination like that. For instance, as I stated earlier, which we debated, whether it was a presumption or not, the knife itself is not visible in the video. That is number one. It's not clear from the video that anything was used other than a fist. The video itself is a long lens, medium shot, where a camera is a distance away from the Bishop Emmanuel, so it's not absolutely clear. The footage accompanying the video has no audio. It doesn't have any gratuitous or exploitative type of sound. It's not a close-up in slow motion, exaggerating what is happening. You can see people in the congregation rushing to defend the bishop, which is something that is understandably a reaction of the parishioners. Like I said, it doesn't accompany any music that glorifies the attack or does anything to bring more attention to the attack. It actually depicts a real world issue, and it was a newsworthy issue that is legitimate discussion at that point that went global. And so when you look at all of these things, yes, those are the things that we look at when you decide, is this something that extends that horrific? Was it a horrific attack? Of course. But when you look at the video itself, the video doesn't cross the threshold as, say, something that is much more glorifying or much more horrific that we have seen in other videos by which we've taken different measures. So yes, you're asking if we had context. We did have context, and that was the decision made within that context.
In fact, I wasn't just asking if you had context. I was asking if the internal assessment was that it was a difficult case that was close to the line.
I wasn't there to determine whether they thought it was close to the line or if it crossed the line, or I wasn't part of that discussion. So I don't know the answer to that.
It's still available on X, and presumably you've had discussions prior to giving your evidence to understand what the corporate thinking was. Because of the horrific nature of what's shown on that footage, outside observers might think that it's difficult to understand why it wouldn't be seen as being very close to your thresholds, even if the assessment was it didn't get over the line. Can you understand that?
I mean, I can understand that. Yes, I can understand that perception.
Thank you. If we could have back on screen, please, what we had before, Sarah, just to finish off on this policy, page 13. Page 3 of 0013. In terms of gratuitous gore, it's described as media of humans or animals that depicts excessively graphic or gruesome content related to death, violence, or severe physical harm. Now, these are ors, they're not ands. And again, media of humans that depicts excessively graphic or gruesome content related to violence or severe physical harm. Again, this footage, you can make a case to say that that comes within that definition as well.
Sure, you
Yeah.
can make a case.
And then, if we go to the bottom of page 3, there's the provision, I think, that people are allowed to post material that contains violent media as long as it doesn't come into the excessive gory category if it's properly labelled to help ensure under 18s, which we should understand to be under 18s who've self-declared that they're under 18s, that it's not visible to them. And then the top of page 4, in terms of what's allowed as graphic media which should have a warning, includes violent crimes or accidents, bodily fluids including blood, serious physical harm including visible wounds. That's permissible with a content warning, yes?
Correct.
Thank you. And then I think if we just go down a little bit further on page 4, there's also the indication that you take public interest factors into account when reviewing reports related to images and videos that depict deceased individuals. We might not remove that media or limit exposure even on receipt of a valid report. And if we can just expand again, I think it's also the case that excessively gory media, final bullet point, that is otherwise removed may remain on the platform if it's associated with newsworthy events to raise awareness or to call for political action and is properly labelled with a content warning. Now that's fairly stark because as I understand it, what it means is content that would normally be too excessively gory may still be allowed up if the contextual factors mean that it's very newsworthy and it's being done for a benign purpose of raising awareness or calling for political action. Is that how we should understand that?
Well, I don't think that's a benign purpose. I think that the whole purpose of the platform is to have global discussions about what's happening in the world. And as I said, censorship is not something that we take lightly. And so what you're assuming is that having a political dialogue or talking about a horrific act is benign. And that's not accurate.
Forgive me, all I'm asking is what your policy means. All right, I'm not assuming anything. Just look with me at the final bullet point, if you would. Your policy says excessively gory media that is otherwise removed, so this would normally be prohibited, may remain on the platform if it is associated with newsworthy events, and then the words of your own company's policy, to raise awareness or to call for political action, and is properly labelled with a content warning. And I'm not assuming anything, I'm just trying to understand what this means. And it seems to be saying something that's very gory, which normally we wouldn't allow on, we may allow to stay if it's newsworthy and if the intent appears to be to raise awareness or call for political action.
Correct. If there is a war underway and or there is an attack or something that happens that is a global newsworthy event, those images are marked as such, as gory or whatever they may be, sensitive media or adult media, or it'll even say graphic or whatever whatever that moniker is on there. It could be that somebody can want to take a look at that and understand what is occurring. To just completely act as if seeing something horrific in and of itself is a trigger point for human beings is not an accurate statement. It is absolutely important for people to understand and see and have a dialogue about what is happening in the world globally. And that is very uncomfortable. And sometimes it is not something that I would want to see or really, but it is important for me to see it. And so you take any sort of video that is a reflection of an attack on people, or a war situation, or famine, or disease. These are very, very sensitive videos. And if that's something that we are doing and we're talking about globally, then yes, we do believe that that is a place on the platform for people to understand what's happening, to have a conversation about it, and in some situations does call for political action.
Do you understand the concept of the straw man fallacy?
Sure.
Yeah. I'm not suggesting for a moment that any footage that is horrific, because I think your answer was saying I'm seeking to make a link between anything that is horrific and causing harm. And in fact, I'm not, but I am specifically challenging you about a horrific video footage of what is currently understood to be a ferocious stabbing attack by a terrorist. And X is thinking that that remains appropriate to show the footage of that actual attack. That's the context of my question, so should we stick with that? Can we turn, please, to XRUC 4014? This is the Violent Organisations, Violent and Hateful Entities policy. And a similar theme of questioning from me, if we may, please. If we look at page 2 of this policy, do we see at the top under this policy, you can't affiliate with or promote the activities of violent and hateful entities. Examples of the types of content that violate this policy include, but are not limited to, doing the following on behalf of, indirectly or directly for a violent or hateful entity, engaging in or promoting violent acts. Now, in relation to that, once it became known to X that the perpetrator of this attack was alleged to be a terrorist and to have acted out of a terrorist motivation. Again, I'm not going to suggest that this was a clear-cut case, but did X see the risk that by continuing to host this material, it could indirectly be promoting the activities of violent and hateful entities, in that the further notoriety and the further coverage given to the attack online could be seen, on one view, as giving it more fuel, promoting it, even though it's not associated with anything that is glorifying it or encouraging it, but its mere repetition could get close to offending this policy.
I don't know that that was, and I don't know that that dialogue happened, and I wasn't part of a discussion that could say that that video reaches that level of, I guess you can say, assumption. But let me give you a little bit of maybe a personal perspective on this that could put into context how we should maybe be thinking about this. So as I stated earlier in the discussion, I was watching that video live. And the reason I was watching that sermon live, is because Marmari is a bishop in my church. He just happens to be in Australia and I happen to be in the US. And I'm a devout parishioner of the Assyrian Church because I'm an Assyrian Christian. What I see happen and what I saw unfold, which everybody here likes to point out the horrificness of it or the tragedy that is in there. My experience was different, and let me explain to you why context matters. I saw a miracle unfold that day. People saw a monster. I saw an angel protecting Marmari. Where people saw a helpless victim, I saw men, heroes, parishioners, rushing to save him. And if you continue to watch what unfolds in that video, through that sermon, and moments after, as men are holding the assailant down to try to protect Marmari until the police arrive, Marmari reaches through the people and puts his hand over the head of the assailant and prays for him. and has since then been continuously saying through all of his speeches and all of his dialogue that this gentleman, this assailant is his son and somebody that he prays for every day and somebody that he has forgiven from the moment that it has happened. And so I want to just take a moment, because I think that what we focus on in every single scenario is something that is so horrific, and that we use these situations in order to minimize what is an important dialogue in this world, in order to minimize what people see in the guise of, under the guise of safety. And I don't believe that. I don't believe, and Marmari says it over and over again, do not use this attack and do not use this video as a way to censor people's information and access information and to free speech. That is not an acceptable use of what this is. And so I'm going to follow his teachings, and I'm going to instead, in this hearing, tell you that what I see in that video is very different than what you see in that video. I actually see hope. I actually see faith. I actually see forgiveness. And so, yes, I do watch that video, and I watch it for those reasons. For you to take that away from me under the guise of safety, that isn't justice. That is tyrannical overreach.
In relation to what may be thought to be the commendable reaction to the attack from others, and of Bishop Emmanuel thereafter, there'd be nothing to stop editing out the actual footage of the seconds of the attack itself to show the lead up and the aftermath, to show the power of what you're doing, but without having the graphic imagery associated with a terrorist attack. So while one understands the power of the evidence you've just given, there would be a way to find a compromise and still reflect a concern about the harmful impacts of actually repeating the actual act of what may be thought to be a terrorist stabbing. Would you agree?
I would say that, in the words of Ben Franklin, those that give up essential liberty to purchase a little temporary safety deserve neither liberty or safety. And so I don't agree with that statement.
So I was hoping that we were going to be able to finish this witness before breaking for lunch, but I fear that that may not be possible, and I'm conscious that we're only 5 minutes away from the 90 minutes. So if we could take a shortened lunch break now, I'd be grateful. I don't know whether we might contemplate perhaps 10 to 2 or something of that kind.
Yes, certainly. We're very nearly finished. I'm very sorry we haven't quite got to the end of your evidence. We're going to take just a reasonably short break now, and we'll sit again at 10 to 2. Thank you very much. I'll rise.